You can get a divorce on paper, or she can get a divorce on paper.
Yeah, I already got it.
But so you have it filed?
Yeah, it's already in the process.
All right. So you understand you're not to have contact with her. She's done. Jerry Williams, could I have parties approach, please? And probation, this is an application. All right, the court is calling 2023 CR 9279W, State of Texas versus Jerry Carl Williams. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense.
Robert Brobach for Jerry Williams.
And are you Mr. Williams?
No.
Counsel, have you received all the discovery and did you review it with your client?
Yes, ma'am, I have.
Court will find that the state is in compliance with discovery. Mr. Williams, I'm going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Off the record for a moment. So attorneys, you all are blocking the door where the inmates come out. And I forgot to make this announcement. The deputies are in charge of court security. If something happens and you are in their way, they have my permission to make the court safe by whatever means they're making the court safe. So if you're in their line of vision, that's on you. We're back on the record. All right, did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict and hold you over for trial? Did you understand your attorney has 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? You don't have to speak up so the court reporter can hear.
Yes, ma'am.
All right. Did you understand by entering this plea, you were giving up those rights?
Ma'am.
And did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.05 and 26.03 of the Code of Criminal Procedure. Going to show you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Going to show you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, ma'am, I do.
State, are you proceeding on the information as presented?
No, Your Honor, the state moves to proceed on the lesser included violation of protective order Class A misdemeanor.
Any objection?
No objection, Your Honor.
I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the offense of violation of protective order or bond conditions as a Class A misdemeanor? Range of punishment is up to $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to a $4,000 fine and up to 1 year in the Bexar County Jail?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, he has.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, he is.
Mr. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of violation bond and protective order. There's a $0 fine. The state is recommending deferred adjudication. There's to be no contact with Latasha, Latosha Williams, and anger management course. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, sir.
state.
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 12 months. There be 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. The state offers State's Exhibit 1 and its attachment.
No objection, Your
All
Honor.
right, and state, did you have a chance to speak with the complainant?
Yes, Your Honor.
Mr. White, your client wants to speak to you.
Yes, we did make her aware of this.
All right, thank you. You may continue to confer. Mr. Williams, I'm showing you what's entitled a waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Right.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am, aware.
Anything you wish to say on behalf of your client?
I think he'll follow the rules, Judge, and understands what he needs to do.
All right.
Yeah.
So, Mr. Williams,
Yes, ma'am.
do you have any children?
Yes, ma'am.
How many?
Much.
Age?
Well,
All right, and is this one child? Is the complainant the mother?
No.
All right. So what is your relationship to Latasha Williams? Your wife? How long have you been married?
Year.
1 year. How long have you known her?
2 years.
I'm sorry,
2,
2 years. And how old are you?
32.
Are you employed?
Yes, ma'am.
Doing what?
I'm a truck driver, but I operate heavy equipment right now.
Okay. All right, so I want to explain something to you. She no longer wants to be with you. Now, I mean, you say that's fine, but what I have before me is you contacting her. She doesn't want you anymore. Legally, I guess you all are still married, but in the real world, right, she doesn't want you anymore. She
Right.
doesn't want to be your wife. She doesn't want you contacting her. Do you all have property together? All right, you don't have property together. You don't have children together. Do y'all have friends in common? You don't have friends in common. So it's like the song Maya, The Case of the Ex. You don't have any mutual friends. You don't have any children. You don't have any property together. The only thing you have is name on paper.
Right.
So did you all legally marry or is this common law that you're doing?
Legally, man.
All right. So she doesn't want you anymore. You can get a divorce on paper or she can get a divorce on paper.
Yeah, I already got it.
But so you have it filed?
Yeah, I'm going, it's already in the process.
All right. So you understand you're not to have contact with her. She's done.
Yes, ma'am.
And you should be able to be done with her because you're 32 and you've only known her for 2 years. So you went 30 years on the planet without knowing her. All right.
Yes, ma'am.
And I'm sure, is your mom currently alive?
Yes, ma'am.
I'm sure your mom has told you to move on.
Most definitely. Family members, everybody.
So you need to do it. Otherwise, you're looking up to a year in the Bexar County jail. You understand?
Yes, ma'am.
All right. This is what the court is going to do. Court is going to sentence you to 1 year deferred adjudication, 100 hours of community service restitution. How often do you see your 12-year-old?
He live in Illinois. Only sometimes when I go back to Louisiana, I'll see him. But I just pay child support basically.
So you're not a father.
I'm a father, but
No,
I'm not there. His mom took him to a place where he can have a better education, basically, because it's nothing where I'm from. That's the same reason why I moved here.
well, no. Being a father is more than just paying child support.
I'll be there when I can. But
Well-
if he's in another state, what can I do?
Oh, you can have contact with him. You
I
can
do
be
all that. I
a,
talk to him every day.
you can be a
FaceTime.
person in his life.
I do all.
So it's going to be parenting classes. And the community service hours will not be waived. If you want to pay off your community service hours, you're more than welcome to pay off your community service hours at $7.25 per hour. And there's going to be parenting classes, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs, or either you can do the patch. And we'll do field visits one time per month for 3 months. There's to be no contact with Latasha Williams. And when I say no contact, what that means is you can't have some third party call her, text her. Don't send her flowers. Don't saying, sorry, it didn't work out. You're not to communicate with her at all. Is as if you never met her, you don't know her. Do you understand?
That's not. The parenting class I took in county, would that count for the parent, what you trying to give me? Because I
Oh, yeah. Why did you have to take parenting classes in Ledette County?
Volunteered to take.
No, why?
Why?
Yes.
Took it.
What, were you divorced? What was their child custody issues? Why?
I just took it just to know how to be a better parent, basically.
All right. Well, you need to provide proof of that to probation.
Okay.
All right. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
The removal of my ankle monitor.
Oh, yeah, we're not going to do that yet. But Sean,
Get that.
his ankle monitor can be removed once the complainant is contacted and see if the complainant has issues with that. The state will do that for you. So family violence. On this case, before his ankle monitor is removed, someone needs to contact the complainant and let her know that he's asking that the ankle monitor is removed and see if she has any objections to that. If she does have objections to that, we can come back to court and I'll hear what the reason is. All right. I'm going to show you.
Man, I'm a truck driver. I can't make a living being on ankle. I can't even find a
Sir,
job.
go around. Yeah. Why are you reaching through? They're going to call today. Here's the issue. And I don't think you understand the seriousness of the issue. Because when people come before me, guess what they want? They want these cases done. They want things to move on and they want their life to be back the way it was before they had a case. So the issue we have is a civil judge put in place a no contact order. You violated the no contact order. I've read your violations with her. So obviously there's some issue with you understanding the no contact order. And if you had to come to a criminal court, and this is a felony court, which means the state reduced your case from a felony to a misdemeanor, that means that there are issues with you and you're not understanding a court order. So what would it look like for me to think, oh, now he understands because he's talking to me, a judge, when he was talking to Judge Salinas and it didn't matter. So you understand? So that's why. So I want to make sure that the complainant knows that your attorney and you are requesting that the GPS be removed. If the complainant says, I'm in fear, I don't want the GPS removed, guess what's going to end up happening? We're going to have a hearing. That's the way we do things in this court. Because my job is to make sure that one, when people are placed on probation, they're rehabilitated, and make sure that if there is a complainant out there, that complainant is protected and society is protected. That's my job.
Yes, ma'am.
All right. So I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. So, Mr. Brawback,
Yes, ma'am.
they're going to speak to the complainant today. If you want to hang around and see if they get in touch with her,
Yes, ma'am.
then we may be able to take this up.
Okay.
And state if she is objecting to it and she wants to appear by Zoom, then we can do that today and have a hearing by Zoom.
Yes, ma'am.
So,
I'll be
Mr.
there.
Williams, remain in court.
Remainder. Thank you, Judge.
You're welcome. All right, and then we're ready on Michael Mora. And after Michael, yes, sure. After Michael Mora, it's going to be Leonard Johnson, Michael Martinez, Christian Smith, and Darianne De La Rosa. Thanks for your patience.
Thank you, Judge.
All right, court is calling 2023 CR 4008, State of Texas versus Michael Joseph Moore. Can I have parties announced for the record for the state?
Laura Metzel for the state. Suzanne Kramer for Mr. Moore.
And are you Michael Joseph Moore?
Yes, Your Honor.
All right, you entered a plea in this case on October 5th to count 1 of no contest. The state waived count 2. The court found that there was sufficient evidence to find you guilty. The state was silent on your application for community supervision. Because there is such a length of time for PSIs, the court just ordered your criminal history. And the court will use that as a basis on whether or not to grant your application. The state is silent. Anything you wish to say on behalf of your client?
Yes, Judge, just a few things. While on bond, I don't really remember what got us in front of you, but we were in front of you on something. And you had just given a recommendation to Mr. Moore that he might, while on bond, seek some treatment for himself, which he did do. He started going to Lifetime and his got with a counselor named Peggy McIntyre.
Mhm.
And in fact, he was going to go into the inpatient section of Lifetime, but he got arrested. And I'll just remind the judge, it wasn't for anything other than Mark Garcia with A Action or Cowboy. I can't remember which particular bond company you were
Yes.
with, Cowboy. Although I had been here earlier that morning, he came in knowing I was here after I left and asked Judge Harrell to increase the bond because Mr. Moore apparently missed a check-in. So that's what got him back in custody and unable to participate in the inpatient program at Lifetime. But I also wanted him to because it sounds much better coming from him when he talks about how he was so upset about going to jail because he really wanted to get this help. He had no court order requiring to do it. He did it all on his own. If you would like to hear from Mr. Moore, he can speak with you.
Sure. If you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Michael Mora.
All right. Is,
And Michael, I had talked to you about, you will be allowed to speak with the judge about your desires to seek help and why you went and got it, even though you weren't court ordered to do so. Did you let her know a little bit about that?
I just my counselor has just told me how would you feel getting impatient, and I told her yes, I'll do it. You know, I do it just, you know what I mean, just to get the help. And after I got enrolled, I started, my drug tests started coming out clean. I started coming out, you know what I mean, negative on my UA. So I felt like it was a good help and it was helping me.
So, I mean, I'm not sure that he's ever really had any kind of help before. I'm not sure that he's ever before. He's getting a little bit older now, had the desire to seek help, but he did it on his own. You did not court order him. I do not believe to do it as a condition of bond. And I think that speaks very well for his incentive to do well on this probation, if you so grant it.
just 1 second. I'm being told that you pled to 2 cases and I only have 1.
Oh, you know what? It was like 4,008 and yeah.
Yeah, 4,008 and 3876, Your Honor.
Okay. All right, so they're gonna give that file to me. So we're back on the record. And we're also on the record in 2023 CR 3876. Is that correct from both
Yes, ma'am.
sides? All right, and that's an evading case. All right, State, I know you're silent, but are there any fact issues you wish to bring to the court attention?
No, Your Honor.
All right, Mr. Mora, people say all the time that probation in this court is hard. And I guess it is, but I'm trying to do things to help people rehabilitate themselves so they will not be back in front of me again or in front of another court again. So you have a choice. I can grant your application for probation, or either I can sentence you to 5 years in prison on each of the cases. Which would you prefer?
Probation.
Okay. All right, this is what the court is going to do in each case, and the court will note the evading arrest and detention was evading an arrest on a bicycle.
Yes.
All right. So just one moment. Just one moment. Just a correction for the record. The case involving the drug case was on a bicycle. The other evading was in a vehicle. All right, in each cause number, the court will sentence you to 5 years in the prison, suspended and probated for 7 years. Each case will run concurrently. And it will also run concurrent with 701883. Take in consideration 2023 CR 4009 and 689573. You're to forfeit any weapons. All right, do you have any children? You need to answer.
No, Your Honor.
All right. You're going to be inpatient treatment with lifetime recovery. And that's to be transferred by lifetime recovery. So once they pick you up, you'll be allowed to go. We're going to start off with GPS. And that'll be GPS for, let's do 4 months.
Will that be full or partial, Judge?
We're going to start off with full because he should be in his recovery at lifetime. And if
Okay.
lifetime feels that it's time for him to start working, they can approach the court.
Thank you, Judge.
And I'll ask that the fees are waived or deferred. There is to be the UA hotline and probation. I'm sure Lifetime Recovery is doing their drug testing as well. If you want to accept their drug testing for that, you can. Proof of employment within 90 days. There should be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And field visits 1 time per month until further notice. And probation, with regards to field visits, if you all know that he's at Lifetime Recovery, you can just call or either accept the fact that he's at Lifetime Recovery. Probation, is there anything else he needs?
No, Your Honor. Are you regular reporting via Zoom or in person?
Yes. All right, is there anything else you need from the court to be successful?
No, Your Honor.
Oh, and State, you can continue to confer. And each cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because there's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Mora, This is your chance to get your life together. I will tell you, anytime you use drugs, you never know if that's going to be your last time to use. And if you are providing drugs to other people, that's not good either, because you're building your happiness of somebody else's misery. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge. Maybe be excused.
Yes. And state, I don't know if I have the dismissals for those cause numbers.
I'll get on that. Judge.
Thank you. See, I try to give them a break, but we'll start with the plea case. Court is calling 2023 CR 4064, State of Texas versus Michael Martinez. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Albert Chidas for Mr. Martinez.
And are you Michael Martinez?
Yes, Your Honor.
Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the lesser included assault bodily injury family.
Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand the state is proceeding on the lesser included offense of assault bodily injury family as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, on both.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 24 days in the Bexar County Jail. There are no applications. There's an affirmative finding of family violence, and if the court follows this agreement, it's the court's understanding that the judgment will be satisfied. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
All right.
Yes,
Did you understand that by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offer states Exhibit 1 and all attachments.
No objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports but most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We have a deal for time with the state, and I just want to make sure my client gets full credit for all the time that he's been in county.
Mhm.
He's got 255 days here in Bexar County. But in addition to that, he's got 139 days out of Hidalgo County.
Mhm.
He was held on at the request of Bexar County. And so he sat 139 in Hidalgo. Then he came here he sat in Hidalgo from June 2nd, 2023 through September 25th, 2023. Then he was booked here and he spent an additional 255 days awaiting trial.
Okay,
Or I should say awaiting the MTR.
all right. And state, have you spoke to the complainant?
We have, Your Honor.
And is she aware of this?
The complainant is not cooperative with our office.
And she did submit an affidavit requesting that he not be prosecuted.
Okay. Anything you wish to say, Mr. Martinez?
Just trying to consider the time that I've already served, in addition to what I owe still on the.
All right, court is going to find you guilty. There's an affirmative finding of family violence, 24 days in the Bexar County Jail, give you credit for time served. There's to be no contact with Christina Regalado, 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 and the court will find that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're going to move on to cause number 2020 CR 10481W, State of Texas versus Michael Benjamin Martinez, showing you what's entitled motion to revoke community supervision and state's motion to supplement pending motion. And state's motion to supplement motion to revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Michael Benjamin Martinez who was placed on community supervision in 2020 CR 10481W for the offense of assault of a public servant, bodily injury on October 29, 2020 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, there's an agreement between state and defense.
What allegation are you all moving on?
Violation number 7. On or about the second day of June 2023 in Bexar County, Texas, the defendant, Michael Benjamin Martinez, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True.
Other allegations, are you waiving those?
We're waiving and abandoning the others, Your Honor.
Any objection?
No objection. Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, and sentence you to 5 years in the prison? Were you aware of that?
It's 5 over 5, but we agreed to 4.
No, I'm just,
Oh, sorry, I don't know.
did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, sentence you to 5 years in prison? Did you understand that? And up to a $1,500 fine. Knowing that, do you still wish to plead true to violation of condition number 5? Court will find, knowing that, do you wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
There is, Your Honor,
Yes.
for 4 years, Your Honor.
What are you asking for?
We're asking for 4 years to do, as opposed to the 5 underlying sentence.
And that is the case that he actually has the 255 days of credit here in Bear County and the additional 139 days out of Hidalgo County for a total of 394 days credit.
All right. Was there any restitution in this case?
No, Your Honor.
All right, then the court will grant the motion and revoke. Are you asking the court to follow the agreement that's been reached?
Oh, yes, ma'am, please.
Are you waiving your right to appeal?
Yes, ma'am. Yes, Your Honor.
All right, the court will grant the motion, revoke, sentence you to 4 years in the prison, give you credit for any time served, in Hidalgo County and Bear County. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And you also are not allowed to own or possess any weapons due to your affirmative finding of family violence as well. Do you understand?
Sure.
All right, we can go off the record. You're gonna have to do better with your life. You understand?
Yes, ma'am.
And when things are not working out with you with your significant other, you need to just leave. You understand?
Yes, ma'am.
All right, good luck to you.
Judge, I did want to just revisit one thing about the judgment satisfied case. I think you said no contact with Ms. Regalado.
Yes.
In her affidavit, she specifically asked that there be, I think she was under the impression there was a no contact order and she wanted it removed. So if we could have maybe no harmful or injurious contact.
I understand that you,
My common-law wife, like we've nothing set in stone with between me and her, obviously, because the whole deal, I understand the severity of everything, the family violence is not to be played with. She's thought long and hard about opportunity with me, and giving me a chance, and deciding, what we should do with the relationship, and we're deciding to work, all this out, but she is in agreement with, she really wanted me back on probation, but at the time is, I understand. And I have to do the time, we're just trying to work and fix all this. It would just be very strainful if I couldn't do that. I'm gonna go to prison, so there's no way I'll be able to, go to her house and like do something, evil or whatever like that, whatever the deal is. But we're just trying to being able to reconcile and do all this, like contact would really be necessary for that. I go about and take all the classes that I can, and that's what she wants
all
me
right,
to do.
let's see the file on the family violence case, please. I'll allow you to have phone contact with her. That's it.
And she did write on her affidavit,
No, I understand about that, Mr. Martinez, but here's the thing. I mean, you love her, right? She had bruising in the eye. And then I read the report. The report is not good. And I understand that tempers run high, people get in an argument. And then after tempers settle down, you know what the cycle is? Person will file an affidavit of non-prosecution. And sometimes cases will get dismissed because the complainant can't be found and they found an affidavit. They've signed an affidavit of non-prosecution. Then you know what ends up happening? We have another assault case and we come back here. Maybe somebody ends up dead. And then guess what people say? Judge, it's your fault. State, it's your fault. Defense, it's your fault. Why didn't we do anything? So the person I have standing before me right now, you have not taken any classes, right? Have you taken any family violence classes?
Yes, Your Honor, when I was on probation.
No, I mean, not just now. I mean,
recent, like
yes.
trying to, I am in line to get in the anger management and family violence there at the jail. volunteered for that myself. It's just that they told me on my kiosk, which I know there's records of that since day one that I got to Bexar County. And Hidalgo County didn't offer any of that. Like they didn't even have church there.
All right.
Out there, so or else I would have gladly, and that's one of the things.
What
she
I'll
wants.
tell you is I will allow phone contact only because I'm sure she's probably going to want to put money on your commissary books, but there's to be no in-person contact. You understand?
Yes,
And the
ma'am.
phone contact, I'm just allowing it for her, not for you. And I say that because I know she wants to have contact with you. So yes, you will still be able to call her from the Bexar County Jail. She will probably accept your collect call. You probably shouldn't call a lot because that call costs a lot. I'm sure you're going to call her from the prison and she's going to want to accept your call. But I am ordering that there's to be no in-person contact with her. You can only have phone contact with her. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.